Now, a company by the name Highplast Limited is back to court over the plastic ban effected in the country. The company is a manufacturer of plastic bags, and they've given the government a notice of 30 days, specifically the Attorney General, over the declaration to ban plastic bags in the country without properly consulting the stakeholders and thus giving inadequate and unreasonable notice against them. The company says the unlawful declaration has led to their loss of businesses, as the actions of the minister have led to default in losses, numerous layoffs and prospective suits from employees and suppliers as well. Joining me in studio now is Eddie Orinda, who is the lawyer for that particular company and drafted that particular notice from the Attorney General. So for the sake of our viewers, I just want us to go through this notice to the Attorney General. What does it say? What does it mean?
Thank you, Akisa, for having me here this afternoon and for the opportunity to articulate the legal issues around the plastic ban and the notice, Gazette notice that was issued by the Cabinet Secretary for Environment and Natural Resources. In fact, there were two notices. The first one was 2334 of 2017, and the second was 2356 of 2017, dated 28th February 2017 and 14th March 2017, respectively. Those two notices sought to place a ban on manufacture, use, and importation of plastics, which has had very, very diverse effects on clients like mine who were engaged in the manufacture of plastics. The notice effectively took effect in September because it gave a 6-month period within which the businesses were expected to comply with the notice. And that brings me to the notice that my clients have now issued to the Attorney General of the Republic of Kenya. As required in law, Section 16A of the Government Proceedings Act requires any claimant to furnish the government with a 30-day notice over whatever claim of any nature before a lawsuit can actually be instituted in court. The nature of that notice is such that my clients, under the circumstances, considering that a separate case that was filed by the Kenya Association of Manufacturers through different lawyers seeking conservatory orders on that ban failed to take effect and was therefore upheld. My clients are now suing the government for damages, both exemplary and general, and also seeking declaratory orders from the High Court in defining the extent to which a minister can act in exercise of public policy decisions or making of the same in a constitutional manner and in line with Article 10 of the Constitution, which, among other things, requires the minister to ensure that there's proper public participation. And even further, Article 47 of the Constitution, which provides for a fair administrative act, that you ought to be given an opportunity adequately, and 6 months would not be reasonable under any circumstances, to respond to any measures that will have diverse effects on you.
But the ministry constantly, when it comes to the issue of consultation, the ministry, this question has been posed to the ministry severally, and NEMA as well. And they have constantly said that this is a conversation that started way back, and manufacturers and suppliers have been aware. The 6 months was just for them to be aware that this is a time lapse. After this, we are going to do this.
In fact, I'm happy that the Cabinet Secretary admits that there have been several consultations. But I think there's also been very selective press briefings and reports from the Office of the Cabinet Secretary. Because two very important things that the Cabinet Secretary is not talking about, for instance, is that in the course of the consultations that you have mentioned, certain agreements had been reached. One of them was management of plastic as a waste for purposes of mitigating the effects on our environment in line with Section 86 of the National Environment Management Act. And the same section requires the minister, while it grants the minister power to assess and ban, requires the minister to also provide for elaborate mechanisms through which mitigation can happen. And that was part of the talks that you have referred to. The other part, which the minister has also selectively left out of the reports that have been continuously in the media, is that there was an agreement in good faith to make an extension of that ban, because it was agreed and it was a general understanding that 6 months was not reasonable. I'm aware that having happened, the Kenya Association of Manufacturers requested the minister to give it legal effect by issuing a notice that would then legally extend that period, which never happened. Instead, the minister proceeded to issue the 2 gazette notices, which effectively then banned use, importation, and manufacture of plastics in September. So it has to be understood abundantly well that what my clients are saying is not that you cannot ban plastics. We're all aware of the diverse effects and the environmental effects of plastics. But we have to be sensitive to the fact that unless we have certain pronouncements from the courts regarding how ministers can conduct themselves in exercise of public policy, that rights of the business community are also going to be infringed upon. Some of these businesses, when set up, had legitimate expectations with certain turnovers and certain expectations spanning over 5-10 years. They have loan obligations from banks. They have obligations of a financial nature, for instance, from suppliers. They have obligations towards employees. So while we make the argument, as the Honorable Judge did in the case that was dismissed, filed by the Kenya Association of Manufacturers, that public interest and environmental issues outweigh an interest of the business community, it must also be remembered that if we do not check those kind of powers in line with the Constitution, as provided for under Article 129, that the minister today will talk about the ban on plastic bags. Tomorrow is going to be plastic bottles.
So in essence, what you're saying is the minister did not act in accordance with the law?
Of course, the minister did not act in accordance with the law. If you look at the requirements under Article 10 of the Constitution, which provide for public participation in matters of importance of this nature, and Article 129, which requires and in fact imposes certain responsibilities on the minister to act in a certain way, it follows, and I think it's logical, that, for instance, the parliamentary report on the same issues during the same period of consultation that you referred to would have also been taken into account, because Parliament consists of parliamentarians who also represent the interest of the Kenyan public. And if consultations had happened and certain proposals had been made, even though those parliamentary reports don't have a legal effect, is it not important for the minister to take into account the mitigating factors? And also consider that the same interests we're talking about are the same interests that the same companies have had to deal with by providing employment and directly contributing into the economy.
But even before giving that notice to the Attorney General and the government at large, have the manufacturers, like your client, reached out to the ministry?
There have been several consultations. In fact, even now as we speak, my clients and a lot of other manufacturers do not understand why an agreement that was already arrived at, and in fact a fund created, which was derived out of levies from the plastic manufacturers to assist in the waste management process, has not been talked about, has not been accounted for, and explanations have not been given around issues regarding a predictable investment climate in Kenya, which would give any investor confidence that even though certain policy decisions have to be made, the business interests would be taken into account by having an opportunity, and it's a constitutional right under Article 47, to be allowed to mitigate against those losses. It was clear from the time the ban was, the notice on the ban was issued, that the businesses were going to suffer losses. That was clear. However, what is not acceptable to the claimants is that even the right to mitigate against those losses is literally being extinguished by having all the doors on consultation and public participation closed. So these are the fundamental questions that we must ask ourselves. And of course, another important one for posterity and for purposes, again, of creating a more predictable investment climate. Assess the extent to which a minister can act in exercising public policy decisions in complete disregard of what Parliament thinks about those very issues, because it is true they're of national importance. It is true that they affect all of us. They affect the public in terms of livelihood, in as much as they affect the manufacturers in their endeavors to conduct lawful business and make gainful outputs out of it, and therefore that those decisions must be done in good faith and sensitivity to the fact that if we are not very cautious about how this kind of decisions are made, then we are creating very, very serious questions about the investment climate in Kenya. It may not necessarily be limited to the local manufacturers. It extends to anyone who may want to come and invest in Kenya on whatever sector.
The government has constantly said if they stopped to consider everyone's interest in this particular venture of banning plastic bags, this would drag on for years before implementation begins. Don't you think it is a very delicate balancing act for them, with one hand environmental issues coming up from this plastic ban, and on the other hand the business community and the losses they encounter when such decisions are made?
Absolutely, Akisa, and that is a sense of democracy. You don't want to have a business environment in which it appears that policy decisions are based on a dictatorial approach in complete disregard of what the law requires the government to do, even as they make that argument. And if you ask me, I think that's a very political approach to finding a much easier solution. However, in making that argument, I think the government also has to demonstrate the extent to which they have made an effort in, first and foremost, ensuring that those policy decisions are in line with the constitutional values. And one of the most important one is public participation. Is it not important for the Kenyan public to engage in discussions regarding decisions that would have far-reaching effects? As this one has. And it's important to note that at this point, only one claimant has issued notice. But it is highly likely that a lot of other claimants are going to, at the end of the 30-day notice, also petition or enjoin themselves because they have suffered the same losses. And in fact are looking for a decision in principle that would create a more predictable investment environment. And I think it is legitimate, and it would make a lot more sense. And in fact, that would save the kind of trouble that you have described in making those the balancing act. By talking to stakeholders and also just taking into account what they think about the decision that you have to make as a government.
So this 30-day notice is 1 week in. What do we expect to happen within the 3 weeks that would inform your decision to whether file the lawsuit or not?
Well, of course, the most ideal situation would be that my clients get a call for compensation in the sum of 2 billion that they're asking the government to pay, which is an estimate of the losses that they have suffered. But looking at it critically, I think that it would be logical if the government made an invitation over consultations in dealing with these matters, because it is not restricted to the plastic alone. And a part of how this democratic space has been expanded, even from a private sector point of view, is numerous litigations that seek to ensure that there is strict compliance with the law in the exercise of government's decision to implement public policy. So in the absence of that kind of consultation on the way forward, at the end of the 30-day notice, my clients have no other choice other than to file for damages at the High Court.
Eddie, thank you for coming into News Desk and helping us understand the notice and what we expect to see in the next few days. Eddie Orinda is the lawyer who drafted that particular notice where his client is seeking for compensation lest they sue the government for damages at the High Court. So we will be closely following up this story for you.